This is the reading of your Literary Performance Challenge for week number 10. Paragraph. If the jury cannot reach a decision by the end of the day, the court may sequester the jurors by putting them up for the night in a hotel, period. The jurors may not have contact with other people, newspapers, and news reports, period. Many times, however, the court will allow the jury to go home at night, provided that neither side objects, period, paragraph. If the jurors cannot agree on a verdict, this results in a hung jury, which leads to a mistrial, period. There is no decision in the case, therefore, it may be tried again before a new jury, period. On the other hand, if the plaintiff or the state decides not to pursue the case further, then it is over, period. In that case, the defendant is free from civil liability or criminal punishment, period, paragraph. The jury notifies the bailiff when they have reached a decision, period. The bailiff then informs the judge, period. All the participants gather back in the courtroom, period. When everyone is present, either the jury's foreman or the clerk of the court announces the decision, period, paragraph. In criminal cases, the possible verdicts are guilty or not guilty, period. In a civil suit, the jury will find either for the plaintiff or the defendant, period. If the jury finds for the plaintiff, it will usually set an amount of damages, period, paragraph. Sometimes different verdicts are possible, period. Guilty by reason of insanity is a possible verdict in some states, period. In some very complex civil trials, applying the law to the facts may be too difficult for the jury, period. In this case, the judge may simply ask the jury to decide one or more factual questions, then the judge will apply the law to the facts as determined by the jury, period. The court may ask the jurors how they voted, period. Either lawyer may ask the court to poll the jury, period. This request usually comes from the losing party, period. The court asks each juror if he or she agrees with the announced decision. This helps make sure that the announced verdict is the jury's actual verdict, period, paragraph. After the court reads and accepts the verdict, the judge dismisses the jury and the trial is over, period. The law permits various motions after the court announces the verdict, which may differ from one state to another, period, paragraph. A motion in arrest of judgment questions whether the indictment or information in a criminal case is sufficient, period. It then asks the court to uphold the judgment, period, paragraph. A motion for judgment notwithstanding the verdict may be made after the court announces the jury's decision, period. However, it must be made before the judge enters a judgment, period. This motion asks the judge to enter a judgment for the losing party despite the decision of the jury, period, paragraph. A motion for a new trial asks the judge to grant a new trial based on errors the judge committed during the trial, period. Some states require the losing party to make a motion for a new trial before filing an appeal, period, paragraph. The decision of the jury does not take effect until the judge enters a judgment on the decision, period, paragraph. In a civil suit, the judge usually has the power to increase or decrease the amount of damages awarded by the jury, period. The judge also may make other changes before entering a judgment, period. In criminal cases, the judge normally may not alter the verdict, period. He or she must accept or reject it, period. The judge rejects it by granting a motion for judgment notwithstanding the verdict, period, paragraph. If the defendant does not pay the damages awarded to the plaintiff, the plaintiff may ask for an execution of the judgment, period. Then the clerk of the court will deliver the execution to the sheriff, period. The clerk will command the sheriff to seize and sell the defendant's property, period. The sheriff will apply that money to the amount of the judgment, period, paragraph. If the court convicts a defendant in a criminal case, if the court convicts a defendant in a criminal case, he or she does not necessarily go directly to jail, period. The judge will set a date for sentencing, period. At that time, the judge may consider either mitigating or aggravating facts, period. Mitigating facts suggest a reason for the judge to show more mercy, period. An example may be a person provoked into committing a murder in the heat of passion, period, paragraph. On the other hand, aggravating facts suggest a reason for the judge to impose a tougher sentence, period. An example may be a case in which a gun was used or where the victim was seriously harmed, period, paragraph. To determine the proper sentence, the judge may also use other information from a pre-sentence investigation, such as the family situation, health, work record, and other related factors, period. This information helps the judge find the most fitting sentence, period, paragraph. In most states and in federal courts, the judge alone determines the sentence, period. Some states permit the jury to recommend a sentence, period. This often happens when the death penalty is a possible sentence, period. Some states and the federal government sentence to encourage consistencies, period, paragraph. In a civil case, either party may appeal to a higher court, period. In a criminal case, only the defendant has this right in most states, period, paragraph. Criminal defendants convicted in state courts also have another appellate safeguard, period. They may file a writ of habeas corpus in the federal courts, period. This tries to show that someone violated the defendant's federal constitutional rights, period. The right of a federal review allows the federal judicial system to study abuses that may occur in state courts, period, paragraph. People normally make appeals because of errors in trial procedure or errors in the way the judge interpreted the law, period. Other grounds for appeal do exist, period, paragraph.